Well, and with those views and aspects about the data economy, we'll come to at least one part of that. Yet again, Axel Voss just also mentioned that international data transfers and, of course, the privacy shield and free data flows are important to be secured in the future as well. And I'm very glad that I can welcome a speaker today who is absolutely an expert on the issue, because Emily Hancock, she's the Chief Privacy Officer and a Senior Director at Cloudflare, will talk about how to protect privacy and data flows across borders and how to achieve innovation in times of the regulatory uncertainty that we are in. So please join me in welcoming Emily onto the stage. And Emily, the floor is yours.
Hi, I'm Emily Hancock, the Chief Privacy Officer at Cloudflare, and I'm so happy to be here with you today to talk about the very real complexities that organizations are facing across Europe as they try to run their businesses and serve their customers in the digital era. I also want to talk about how we at Cloudflare have been developing answers to these challenges using a combination of technological and organizational solutions. Now, if you haven't heard of Cloudflare, we are a company that works to make websites, corporate networks, and other internet applications faster, more efficient, more reliable, more secure, and more private. We operate a global network, and we have core data centers in the US and in Europe. And as a US company with a large European customer base, we are extremely familiar with the pressures our European customers face. They want to increase the security of their websites and applications, but they are under pressure not to use US service providers because of the regulatory environment. So let's talk frankly about what European businesses and even European government institutions are up against. The internet was not built with security or privacy in mind. I talked about this in my speech here last year. But every day we are provided with ample evidence for just how important internet security and privacy are. Thanks to the COVID pandemic, things that didn't used to be online are now regularly online, like this conference. And many of us haven't returned yet to offices full time and may never do so again. So there's no going back. And to go forward, we may not always be able to stay one step ahead, but we do need to be able to respond to and fend off cyber attacks from cyber criminals who will try to steal our data, take down our websites, or disrupt our economies and critical infrastructure. The internet is global, and these threats are global threats. And when we work to fight these criminals, we need to be able to draw on global data about attack trends. If we have to segregate attack trends by jurisdiction, we may miss key intelligence. Cyber criminals don't care about our jurisdictional boundaries, but governments very surely do. And in the interest of protecting their citizens, European governments have taken positive steps to enable their law enforcement agencies to get the data they need to catch the bad guys, to create cybersecurity regulations aimed at establishing baseline security measures and incident notification rules, and to create privacy-enhancing regulations to ensure people's fundamental right to privacy. But what happens when the laws of one jurisdiction conflict with the laws of another jurisdiction? That is precisely what we are dealing with today in Europe and the US. More often than not, European businesses and even government institutions want to use US cloud service providers like Cloudflare because they may provide better performance or user experience. In fact, having a global network may in fact be a security imperative. In the days around Russia's invasion of Ukraine, we saw a number of DDoS attacks against Ukrainian sites on our network. And the fact that these sites could use our global network to mitigate those attacks meant that these DDoS attacks were barely noticeable rather than crippling. So cyber criminals don't care about our jurisdictional boundaries, and jurisdictional boundaries should not hamper our ability to fight those criminals. But entities wanting to use US providers while complying with applicable laws are caught between a rock and a hard place thanks to conflicting legal regimes. And this is a real problem for cloud adoption in Europe. The Europe Commission has set a goal of 75% of EU businesses using cloud computing services, big data, and artificial intelligence over the next decade. Achieving this ambitious goal will be made even more difficult if our respective governments can't reach a solution to enable data flows between the EU and third countries like the US. So let's start with a closer look at the conflicting legal regimes of the EU and the US that are causing all this trouble, specifically the US Cloud Act and FISA 702 on one hand, and the GDPR and the Schrems II court decision on the other. In March 2018, the US Congress passed the Clarifying Lawful Overseas Use of Data Act, the Cloud Act. The idea behind this law is that governments that protect their citizens' due process rights and civil liberties should be able to get access to electronic content related to their citizens when conducting law enforcement investigations wherever that data is stored. In the EU, the Cloud Act has become shorthand for the US government can get anyone's data wherever it's stored. But that's not really what the Cloud Act is meant to do. The whole point of the law is to recognize that with advances in cloud computing, where data is stored should not impact law enforcement's ability to use legal process to get that data. Now, the Cloud Act enables the US government to enter into an agreement with another country's government so US law enforcement can obtain data stored in the other participating country for the purpose of investigating and prosecuting certain crimes and vice versa. Right now, for example, US law prohibits a US company like Google from producing the content of any Gmail communications to the German government, even if it would be relevant to a crime in Germany involving a German citizen. But if the US and Germany had a Cloud Act agreement in place, that agreement would allow German law enforcement to get data directly from Google. Now, so far, Germany and the US have not entered into such an agreement, but we believe it would be in the mutual interest of law enforcement authorities from both sides to do so. Also, the Cloud Act does not authorize bulk surveillance requests by law enforcement. Instead, law enforcement officers can only obtain content subject to a warrant issued by a court that has made a finding that there's probable cause of a specific criminal act. Now, there is one thing that the Cloud Act does that is really important. It supports the ability of US companies to object to US law enforcement demands that would violate other countries' laws, such as the GDPR. So for countries that have signed agreements with the United States, the Cloud Act permits notification of the conflict, and it provides an opportunity for those countries to weigh in on whether the information may be accessed. Now, in 2019, the European Data Protection Board issued an assessment of the Cloud Act and found that the US law enforcement orders for EU citizens' data, except those that have gone through the Mutual Legal Assistance Treaty process, would likely violate the GDPR. For a US company processing the data of EU citizens, this means that any US government legal process for such data that has not passed through the MLAT process presents a conflict of law. And under the Cloud Act, the US company has a legal means to object to that legal process. Now, besides the Cloud Act, many Europeans are concerned about US cloud providers being subject to US bulk surveillance for foreign intelligence purposes. And as you probably remember, the Court of Justice of the European Union in its Schrems II decision specifically examined the US Foreign Intelligence Act Section 702 and Executive Order 12333 in trying to determine whether the EU-US Privacy Shield was an adequate basis for transferring EU data to the United States. First, let's get rid of the notion that EO12333 is actually a problem for Europeans using US cloud service providers. EO12333 authorizes US intelligence agencies like the National Security Agency to conduct surveillance outside of the United States. It does not apply to any data transferred to or located in the United States. Further, EO12333 does not have provisions to actually compel the assistance of US companies. Now, meanwhile, FISA 702 is not used to just dragnet collect every single thing. It's used to collect communications like emails or text messages. And before exercising its FISA 702 authority, the US government must receive a certification from the Foreign Intelligence Surveillance Court. And US companies do have the ability to object to such orders and challenge them. Even though these US legal authorities aren't the threats they are sometimes made out to be, in light of the concerns around the Cloud Act and Schrems II, any company that processes personal data, whether in Europe or the United States, needs to think about its data disclosure policies. So for a US company doing business in the EU, developing a consistent, principled approach to responding to government data requests is critical. At Cloudflare, regardless of what a government is asking for, there are certain standards we believe must be followed before we turn over customer data. First, we require government entities seeking access to personal customer information to obtain appropriate legal process that has been judicially reviewed. Second, we believe our customers deserve to be notified when we receive any type of legal request for their information. We provide that notice before we disclose the information unless prohibited by law, and we will fight requests that unnecessarily restrict our ability to be transparent with our users. Third, we believe it's important to be transparent about the number and types of requests that we get from law enforcement, as well as how we respond. So we publish a transparency report twice a year, and we make it available on our website. Maybe most importantly for a US company doing business in the EU, we ensure we are pushing back against any law enforcement requests that we believe are overbroad, illegal, or wrongly issued. And this includes exercising our rights to push back on US government data requests that conflict with the GDPR. If you're an EU company looking to engage a US service provider, you'll want to look for evidence that the service provider has done what it says it will do to push back against unlawful or overbroad data requests. In 2013, for example, we challenged a classified US government data request called a National Security Letter because it did not allow us to disclose the request to our customer without any sort of time limitation. We believe the government should be required to justify any non-disclosure provision, and that any non-disclosure provision should be explicitly time limited to the minimum time necessary for the purpose at hand. So we worked with the Electronic Frontier Foundation on a legal challenge to the letter. We won that challenge and never produced that data, although we were prohibited from talking about the effort for years while the litigation was ongoing. In addition, beginning with our very first transparency report in 2013, we've made public commitments about how we approach requests for data and public statements about things we have never done. We call these public statements about things we have never done warrant canaries, with the idea that they serve a signaling function to the outside world. Regulatory entities have started to recognize the value of such privacy commitments, particularly when they can be enforced by contract. In fact, the commitments we've included in our transparency report for years, and that we include in our standard data processing addendum for our customers, are exactly the types of commitments the European Commission included in the revised 2021 standard contractual clauses for compliance with the GDPR. Cloudflare's commitments are: 1, we have never turned over our encryption or authentication keys, or our customers' encryption or authentication keys to anyone. 2, we have never installed any law enforcement software or equipment anywhere on our network. 3, we have never provided any law enforcement organization a feed of our customers' content transiting our network. 4, we have never weakened, compromised, or subverted any of our encryption at the request of law enforcement or another third party. A definitive, up-to-date list of these commitments is available on our transparency report page, along with an RSS feed, so you can sign up to find out if we ever have to take down one of these warrant canaries. We feel very strongly about these commitments and about pushing back against legal process that may violate the GDPR. But if you're a European company or a government institution and you are basing your decision of which service provider to use solely on your Cloud Act or FISA 702 concerns, I respectfully submit that you are missing the forest for the trees. In today's online world, we are dealing with threats to data privacy and security around every corner. And when you choose a service provider, you want to choose a service provider who has been thinking about the totality of risk. As a company dealing with the personal data, you need to be thinking bigger than the extraterritorial effects of laws and the specter of government legal process. You need to be looking for services that will provide privacy and security for your data, regardless of borders. At Cloudflare, we've been thinking about data privacy and security risks and solutions since before the GDPR and the Cloud Act became part of our collective vocabulary. We take a proactive approach towards privacy, and we believe that privacy is not only about responding to different regulations, but privacy is about building technology that helps customers do a better job of protecting their users. It is about minimizing the exposure of sensitive data and protecting user privacy and personal information. It is a critical part of helping to build a better internet. Now, because a more private internet is a better internet, we think about building privacy into everything we do. And this is something that every business can do, and something the GDPR encourages by requiring that entities engage in privacy by design. So, what does it look like to build privacy into your data handling practices? Well, this is probably stuff most of you know, but first you need to think about the data you process and store. The Fair Information Practices, the GDPR, and other data protection guidance stress the importance of data minimization. Only collect the minimum amount of data you need to do business. Second, you should only use the data you collect and process for the purpose for which you're collecting and processing it. And third, you need to invest in privacy by design, privacy enhancing technologies, and best in class security measures to protect your data. Fourth, you need to think about how you can localize data if you think you need to in light of your regulatory obligations. Even though, as I hope you'll agree by the end of this talk, localization is by no means a proxy for better data privacy. Now, we take these principles to heart at Cloudflare. For example, when companies use our most popular application layer security services, we don't store any of the content that flows across our network, and we minimize the data we do collect. We store logs of end user traffic to our customers' websites only for as long as needed to provide the service. And customers can choose for us not to store any end user traffic logs at all and only keep aggregated analytics. For our 1.1.1.1 public DNS resolver, we don't store any end user logs. And if you don't store data, or you only store minimal data, then you can't do anything with it that would surprise the people who are using your services. The importance of this approach is underscored by the recent EU Court of Justice ruling that says that retaining metadata is incompatible with fundamental EU privacy rights. And when it comes to purpose limitation on the data we collect, unlike a number of large US service providers, Cloudflare doesn't make money off profiling the end user data that transits our network. We have a subscription-based business. We make our money because customers pay us to provide solutions to make their websites and networks safer, more secure, faster, more reliable, and more private. And when we process our customers' end user data, the only thing we do with that data is make sure good traffic gets where it's supposed to go, and bad traffic, like DDoS attacks and malware or bots, gets blocked so it can't do any damage to our customers' sites and networks. We also believe companies need to explore and invest in privacy-enhancing technologies to protect their data, and they need to look for service providers committed to privacy-enhancing technologies as well. Privacy-enhancing technologies is a new name for a set of tools, techniques, and practices that have been a focus of research and development for many years. Let me give you a few examples of the innovations we've developed to deal with these challenges that we all face. Cloudflare is proud to have partnered with Apple to develop the Oblivious DNS over HTTPS, or ODO, standard that Apple's iCloud Private Relay uses. With Private Relay, the metadata connection between an end user and the website they want to visit is broken. No one relay can see both the IP address and the destination website. Splitting connections in this way prevents websites from seeing end user IP addresses, and it minimizes how much information third-party entities watching the traffic can collect on user behavior. We've also partnered with the period tracking app Flow to implement an emerging IETF standard called Oblivious HTTPS, which separates data content from IP address information. This means Flow will see the contents of a request, but won't know where it came from, while the relay will know where the data request is coming from, but won't know anything about the contents of the request. Now, in addition to privacy by design and privacy-enhancing technologies, there is also an obvious need to put in place security measures to keep private data private. Appropriate security measures are critical for protecting data privacy, no matter where the data is transiting or being stored. The EDPB has been clear that appropriate security measures are necessary supplementary measures for cross-border data transfers outside the EU. At Cloudflare, we launched Universal SSL back in 2014. We made the ability to use encrypted connections free for all of our customers because we knew that that would help build a better internet. And we continue to ensure that security measures are best in class by using state-of-the-art encryption protocols designed to provide effective protection against active and passive attacks with resources known to be available to sophisticated attackers, including state actors. We also have employed our own Zero Trust suite of products to protect our own internal network, which in turn protects our customers and their end users. Bad actors are out there, and companies and government entities deserve to be able to use service providers who can offer them state-of-the-art security and privacy measures to protect their own networks, as well as the personal data they process on behalf of their customers. Restricting the ability of an entity to use the best service provider simply because of the entity's founding jurisdiction fails to recognize the very real ways in which technology can protect better than laws can, especially on the borderless internet. But we understand there is a real concern about giving data subjects the comfort that their data has the same legal protections in the cloud as it would if it were stored on a local server. And we understand the real concern that data subjects in one country should be able to have the opportunity for redress if their data is obtained by a government in another country in a way that may violate their legal rights under the laws of their home country. And that is why we were really excited to hear news the other day that the US is very close to issuing an executive order designed to address European concerns over surveillance practices in the United States. This would allow the European Commission's ratification process to move forward. Unfortunately, this process could take another 6 months. And in the absence of a transatlantic framework, many of our customers see decisions from data protection officials that seem to suggest almost no cross-border data transfer to the US can be acceptable, and they worry. So we, like some other US service providers, have developed solutions to allow for data localization. With Cloudflare's data localization suite, customers can use Cloudflare's powerful global network and security measures to protect their businesses while keeping the data we process on their behalf local. A key part of our data localization suite is our regional services offering, which restricts packet inspection to data centers in the EU. When regional services is enabled, regardless of which data center traffic first hits on our global network, rather than decrypting it at the first hop, we forward the TCP stream in encrypted form. And once it reaches a data center inside the EU, we decrypt and apply our layer 7 security measures to prevent malicious traffic from reaching our customer sites. Our data localization suite also helps us keep metadata in the EU. With our customer metadata boundary component, no end user traffic logs that Cloudflare processes on behalf of our customers will leave the EU. In addition, our data localization suite's GeoKey Manager feature allows customers to determine where they store their decryption keys. And our keyless SSL feature provides a way to avoid having Cloudflare hold our customers' decryption keys at all. A number of our customers have used our data localization suite with great success. Still, we would prefer a world in which there was no need for it. Unfortunately, the trend is quite the opposite. In the time since we have launched our data localization suite, we have seen European regulators continue to narrow the circumstances under which cross-border data transfers are deemed acceptable, even though the Schrems II court and the European Commission clearly laid out a basis for risk-based decisions meant to allow data transfers. The example the EU is setting is being watched around the world. A number of countries, such as Japan and China, have instituted data localization provisions, and other countries, such as India, are not far behind. And yet, we know that just as US companies don't want to be shut out of the EU market, EU companies don't want to be shut out of other markets because of localization requirements either. The location of the service provider shouldn't matter. As I've shown, there are technologies that make location irrelevant. In fact, the EU and the US have an opportunity to show leadership on a model for free flow of data while protecting privacy and security. The US is already working with a number of countries in the Asia Pacific to create a global cross-border rules forum to allow for the free flow of information while respecting certain common principles for handling that data. Should the EU be left behind to become an isolated data island? I don't think any of us want that. We're dealing with an extremely complex data protection regulatory environment these days, but there are promising opportunities for a path forward. So I'll leave you with 3 final thoughts. First, We need governments to come together and ensure that we face a stable regulatory environment in which companies can innovate and trade for the mutual benefit of respective economies and societies. Alongside many other companies from both sides of the Atlantic, we've been calling on policymakers to move quickly to agree to a comprehensive framework for personal data transfers that will pass the test of the European Court of Justice. And this will be an important signal for mutual trust and commitment to the transatlantic partnership in these turbulent times when we need to stand together more than ever. And bilateral cloud agreements between the US and member states will help too, as will a uniform, well-informed decisional practice of Europe's many DPAs. Second, we can't leave data protection only to the regulators, legislators, or the courts. All companies need to continue to focus on minimizing the personal data they collect, limiting the purposes for which they use that data, and investing in best-in-class security to protect that data. Third, companies can take very real steps to invest in technological innovations that can build privacy into the internet. We need to support and emphasize privacy by design and privacy-enhancing technologies. At Cloudflare, we are trying to do our part to advance these technologies, and we're working with many partners and our customers to help them do theirs. I really look forward to seeing what other privacy-enhancing innovations we'll see in the future, and I very much appreciate the chance to talk with all of you today. Thank you.